So I want to talk about the Solomon Allens in another video. That one would be relatively quick. It's just fascinating, that's all. This notion of independent state, Solomon Allens, in theory. It's almost a hypothesis, almost. Because the moment that Solomon Allens does something that other powers don't like, all of a sudden Solomon Allens is no longer independent, despite the fact that it is supposed to be an independent nation. And the arguments that were used for Ukraine, oh, it's an independent nation. It can do whatever it wants. If it wants to point weapons at Russia, it can point weapons at Russia. It can do that. It can do that. It can be part of NATO. It can do anything it wants. It's a sovereign nation. Solomon Allens, we're going to work with China. That is intolerable. Tolerable. We're not going to accept that. We're white, goddammit. Can't do shit like that. Either way, in any situation, it's going to be very interesting considering Solomon Allens is dealing with China for security reasons. And you're getting Western backers who are coming into the country trying to reopen the embassy, Peace Corps, and all that good stuff. So that video is going to be fascinating. Even US-8, which is the fascinating part, because that's a front for the CIA, which means freedom is coming to the Solomon Allens. But no, the one I want to talk about today is Garland. DOJ is suing Idaho before an abortion law that basically is trying to go into effect later in August. I think it's the 26th, give or take. And I want to make sure that's right. Where is it? It's the 20-something. I put it that way. And I think it's the 26th. So either way, August 26th. So the DOJ, Merrick Garland, led by Merrick Garland, comes out with a press conference basically saying, we are suing Idaho. And we're suing them because he used a technicality. I'll let you hear it. But basically, he's arguing that hospitals that receive Medicare, by law, have to give emergency treatment to people who are in their emergency rooms before you allow those persons to leave. Which means if somebody is in your hospital, they can't afford to pay for X or Y, you can't kick those people out. All things being equal, you're getting money from Medicare, you must serve those people. You must give them the emergency care that they need in order to preserve their life if possible. So Garland is saying that that abortion law that they passed in Idaho, even though it has provision for death, specific death, she will die if I don't do X or Y, it doesn't have one for basically jeopardy of the mother's life. Well, she won't die, but she'll be maimed. Yeah, let's not do the abortion in that situation. That's his point. You can't have a situation where the mother is gravely wounded, ill, or hurt, tarnished by having that baby, and you basically prioritize the baby over the mother's life, allowing that person to be in a poor situation. Shouldn't be able to do that. Also, the Idaho law is creating all sorts of weirdness around what doctors can and can't do because the doctors are the one that will be prosecuted. They're basically calling the law, right here, the trigger law, which was passed in 2020, would make providing abortions a felony, punishable up to 5 years in prison. The ban has exceptions for cases of rape or incest if reported to law enforcement to prevent the death of the pregnant mother. Basically, this person in my family raped me, rape baby. I want to get rid of that rape baby, and I live in Idaho. Because I was embarrassed by this, even though there was nothing to be embarrassed about, that guy was a fucking asshole. But because I was embarrassed by this, I didn't tell anybody. And now that I try to get rid of this kid, I tell you I was raped, and you still tell me we still can't still get abortions. Sorry, you can't do it. Gotta use a clothes hanger for that. We, as medical professionals, can't help you with that particular medical issue, which is getting rid of the rape baby that you in no way want. The state is trying to force you to have a rape baby in this situation. And even though you tell somebody, meaning in many cases, people don't tell. When I was younger, I was sexually abused myself. I think I've noted this on the radio once before. I didn't tell anybody. I mean, it wasn't that I thought myself was guilty or responsible or anything like that. It was just embarrassing. And so for me, it happened more than once. My mom didn't find out till I was 24 years old and I was on a hospital deathbed that I was basically telling her as the last thing before, I didn't necessarily think I was going to survive. Well, they didn't think I was going to survive. She was like, what? And then she thought, well, maybe he's in and out because of the medications and stuff like that. I'm not in and out because of the medications. Those medications don't affect me like that. All things being equal, I'm still me. I make it drowsy, but I'm still me. No, I was telling you something that basically happened when I was like 8 years old, and I am now 24 years old. The point that I'm making here is people don't always tell that stuff. And sometimes that stuff can be in the context of a family. Sometimes it could be somebody close to a family. that is not something that always gets told or taken to the police. And I would wager the majority of them don't get taken to the police for action. That stuff is either handled in family, hushed up, or the person doesn't say anything because they may feel responsible, or it's embarrassing. That law is disgusting. The law is disgusting. You're basically forcing these people. 14-year-old child gets raped. The 14-year-old doesn't say anything to law enforcement. The 14-year-old tries to get an abortion, but the law doesn't necessarily allow the 14-year-old to get an abortion. Now, this law hasn't come into effect yet, but you can also think of situations where the mother gets injured, wounded, the mother ends up in the hospital, they need to get rid of the child in order to save the mother's life, but the doctor doesn't want to do that because the mother's life is not prioritized unless the mother is on the brink of death, and so you force the mother, risk the mother's life. This is going back to the Stone Age. In regards to the appraisal of this stuff. Let's be clear, though. This is a nuisance lawsuit. It's a nuisance lawsuit. Idaho can refashion the law to exclude whatever Merrick Garland was basically complaining about and put it back up for adoption. They can do that. Nothing stops them from doing that. Merrick Garland is just trying to stop this specific thing from going through. By August something. Basically, they're trying to push the time forward that these guys are able to put a law in place. Again, there's nothing to stop them from changing the law. This is somewhat of a nuisance lawsuit. And if Democrats lose the House and the Senate, which they may very well do, especially if the abortion issue doesn't catch on wildfire, then what? Then what? We shouldn't be having this fight in the first place, especially not now. Obama didn't even fight for a Supreme Court pick, basically standing there radically impotent as Mitch McConnell steals away his choice. What in the actual fuck? You're the president of the United States. How are you too cool to get into a fight over a pick that is yours, constitutionally yours to make? And if you were able to make that pick, you would have those 7 justices that are conservatives on the court, or how many ever, I think it's 5 or something, that are on the court. No, not 5, 4, 7, 3. Yeah, 7 conservative justices. It wouldn't look like that. It'd be 6-5. Roe v. Wade would still be intact. Before you say anything to me about Clinton, you better talk about Obama. Didn't even fight for a seat. I mean, I've never seen anything that weak. It's not even... Look, in politics, there are times, like I said, work between the lines. There are times that are required radical strength, meaning a muscular response to get across. This is not acceptable. Full stop. And the idea that these guys were basically like, wait, we'll let the Supreme Court die on the vine. We'll let it die on the vine. Because in their head, Hillary Clinton was going to get in and she was going to make her picks. And they didn't necessarily want her picks to go through either for the entirety of the time that she was in office. So in their heads, she would only pick liberal justices. We don't want to give up our conservative majority, so we won't let it go through. That's simple. It was that. Now, how long would that last? Who knows? In a situation where, let's say Congress didn't necessarily change over, let's say the Senate with the Democrats, okay, fair enough, but you're talking about 4 years of that situation taking place. I guess the difference is, though, if Hillary Clinton would have won, there was no way she would have won and Democrats lost the Senate, if that makes sense. Meaning if she wins, she takes the Senate with her. Either way, let's hear Merrick Garland make his pitch about this nuisance lawsuit. Joe Biden, at this point, should have taken a Herculean response. They dragged your sacred cow out to the White House lawn. They put a gun into its mouth, and it blew its brains out. And then they fed on the carcass right there in the White House lawn, looking you in the eye as they did it. That's what took place. And your response to that is to dither and to do nuisance lawsuits. And I do appreciate the nuisance lawsuit, but let's just be very clear. It is a nuisance. It's not something that's going to fundamentally change the thrust of this for the foreseeable future. You weren't willing to get your people online to get rid of the filibuster. That's something you should have did on day one. That should have been eliminated from the Senate right off the bat. And then you should have went through and pushed your agenda through item by item by item to get up to the point where the public could judge you by that agenda and the results of that particular agenda. Again, you didn't do that. You allowed Manchin, couldn't get him in line, couldn't use some kind of presidential authority, couldn't have a conversation with him, couldn't get political pissy with him, where you would basically try to put a knife in him. Couldn't do any of that stuff. And so instead, none of that stuff gets passed, including solidifying abortion into law, including that. And so we finally weakly come out and say something about it. It's too late. You should have codified that into law a long time ago. And now, it's too late. They can get rid of the filibuster now, but at this point, they're not going to do it. Manchin, or for that matter, Sinema, is not going to do it, which means you have basically two rogue Democrats that is not helping you defend the sacred cow that just got shot in the face with the people eating the carcass and looking you in the eye in your offices as they chow down the carcass. What you should have did was had abortions on federal lands. You should have came out, muscular, Herculean even, rip your shirt off, even that's permitted at that point in regards to the president, screamed into the mic, shook your fist at various people. You should have done all of that. You should have been shaking the podium. You should have been shaking with a level of rage and indignation to get across the rage and indignation that the public has at its own self-conception being totally undermined. Meaning, I don't believe for a moment that America's self-conception is of a backwards nation. And yet, because abortion was basically codified into this kind of case law, it was something that was settled ground up until the point where it was no longer settled ground. Well, what does that do to an individual's self-conception of their country when they see their country that half of it can't get an abortion, something that all of them consider to be sacrosanct with America? Choice. Freedom of choice. We care about the mother. We care about the mother more than a zygote. Yes, clump of cells. Absolutely so. But not so much now. In what, half of America? So yes, people who were Democrats to the tune of like 90-something% would have backed anything that you did. They didn't give a shit if you were taking a quarter of it. They would have backed anything that you did. Joe Biden could have performed an abortion right there on the White House lawn, and they would have accepted it as the American public. Mark my words. At the very least, Democrats would have accepted it. But the majority of the country also would accept it. They would, on some level, expect the president to act that way. But that's not what we got. We got an executive order that is somewhat hazy and unclear. And we get Merrick Garland doing pinprick lawsuits to stave off the inevitable. And this, I guess they're trying to look heroic, like Stalingrad or something like that. Look, not so much. That's not necessarily the way this is working in practice. They are going to change their law. And they may even withdraw and change it again in order to evade this, which means that they may basically neuter all of this process before you even get to court. That's what I do. Just change the law. This is Merrick Garland, though. Yeah, this is Merrick Garland.
Good afternoon, everyone. Today, the Justice Department filed a lawsuit against the state of Idaho. The suit seeks to hold invalid the state's criminal prohibition on providing abortions as applied to women who are suffering medical emergencies. Under a federal law known as the Emergency Medical Treatment and Labor Act, or EMTALA, every hospital that receives Medicare funds must provide necessary stabilizing treatment to a patient who arrives at an emergency room suffering from a medical condition that could place their life or health in serious jeopardy. In some circumstances, the medical treatment necessary to stabilize the patient's condition is abortion. This may be the case, for example, when a woman is undergoing a miscarriage that threatens septic infection or hemorrhage, or is suffering from severe preeclampsia. When a hospital determines that an abortion is the medical treatment necessary to stabilize a patient's emergency medical condition, it is required by federal law to provide that treatment. As detailed in our complaint, Idaho's law would make it a criminal offense for doctors to provide the emergency medical treatment that federal law requires. Although the Idaho law provides an exception to prevent the death of a pregnant woman, it includes no exception for cases in which the abortion is necessary to prevent serious jeopardy to the woman's health. Moreover, it would subject doctors to arrest and criminal prosecution even if they performed an abortion to save a woman's life, and it would then place the burden on the doctors to prove that they are not criminally liable. The United States therefore seeks a declaratory judgment that Idaho's law violates the Supremacy Clause of the United States Constitution and is preempted by federal law to the extent it is in conflict with EMTALA. The United States also seeks an injunction prohibiting Idaho from enforcing its law against healthcare providers who provide the emergency treatment required by EMTALA. In the days since the Dobbs decision, there have been widespread reports of delays and denials of treatment to pregnant women experiencing medical emergencies. Today, the Justice Department's message is clear. It does not matter what state a hospital subject to EMTALA operates in. If a patient comes into the emergency room with a medical emergency jeopardizing the patient's life or health, the hospital must provide the treatment necessary to stabilize that patient. This includes abortion when that is the necessary treatment. Any state law that prevents a hospital from fulfilling its obligation under EMTALA violates federal law. On the day Roe and Casey were overturned, we promised that the Justice Department would work tirelessly, protect and advance reproductive freedom. That is what we are doing, and that is what we will continue to do. We will use every tool at our disposal to ensure that pregnant women get the emergency medical treatment to which they are entitled under federal law. And we will closely scrutinize state abortion laws to ensure that they comply with federal law. I would now like to welcome Associate Attorney General Vanita Gupta, who is the head of our Reproductive Rights Task Force, to the podium to share more details from our complaint.
Thank you, Attorney General Garland. The complaint alleges that Idaho's law is contrary to EMTALA because it presumptively criminalizes all abortions, making it a felony for doctors to provide emergency treatment required by federal law, even where a denial of care will likely result in the death of the pregnant patient. The Idaho law flatly prohibits abortion even where medically necessary to protect the health of the patient, such as where women are experiencing incomplete miscarriage or severe preeclampsia. Specifically, Idaho's law, which takes effect on August 25th, places the burden on physicians to prove at trial, following arrest and indictment, that they are not criminally liable. Physicians can only do so by proving that the abortion they performed was necessary for one of two reasons: to prevent the death of a pregnant woman, or in response to a case of rape or incest that was previously reported to the police, or in the case of a minor, to Child Protective Services. Physicians who do not meet this burden face 2 to 5 years imprisonment and revocation of their medical license. And the law provides no defense whatsoever for when the health of the pregnant patient is at issue. Moreover, under the Idaho law, healthcare professionals such as nurses and lab techs face license suspension and potentially revocation for even assisting with abortions. The law thus places medical professionals in an impossible situation. They must either withhold stabilizing treatment required by EMTALA or risk felony prosecution and license revocation. In so doing, the law will chill providers' willingness to perform abortions in emergency situations and will hurt patients by blocking access to medically necessary health care. The United States, therefore, seeks a declaratory judgment that Idaho's law violates the Supremacy Clause of the United States Constitution and is preempted by federal law where it conflicts with EMTALA. The United States also seeks declaratory judgment that Idaho may not punish medical providers based on their performing an abortion authorized by federal law. And we seek an injunction prohibiting Idaho's enforcement of this law to the extent it conflicts and prevents physicians from providing the emergency treatment that federal law requires. In the wake of Dobbs, the Justice Department established the Reproductive Rights Task Force and to formalize our ongoing work to protect reproductive freedom. One critical focus of the task force has been assessing the fast-changing landscape of state laws and
You get the gist of it. I wanted to play it out because I wanted them to explain the case, and not just explain the case, kind of get into the details of the Idaho law and the reason why they were going after it. Yes, there's a changing landscape because many of the states, especially Republican-held states, they changed their laws. In fact, not just changed them, they had trigger laws. So the moment that the Supreme Court allows X, the law goes into effect. So in their case, August 25th, I could have sworn I think it says 26th, but whatever, August 25th. And so their job at this point is to preempt those laws from taking place by trying to find loopholes in the law that they can basically exploit for reproductive rights. And whether that's a doctor who's like, yeah, that flu that you had was life-threatening. Let's get this abortion on the way. If it's that. But at the very least, for women who are in a situation that they express that contradicts or conflicts with federal law, that you got to do it. The problem that they're pointing out is doctors are under state law, and that state law will have them arrested first and foremost, and that the fact that the doctor is presumed guilty. You're not innocent until proven guilty. That doctor is presumed guilty until that doctor can basically prove that that woman was basically on her deathbed, or at the very least would die without it, with no provision for the woman's health per se in that calculus. Yeah. So if a doctor is confronted with that issue, is that doctor thinking about, oh my God, I can go to jail? And if that doctor is thinking, oh my God, I'm going to go to jail, what is it going to do to the care of the person who he's dealing with, even if it falls under federal law? Does he really want to take that particular flack to get dragged into court potentially as a result? That's the issue. That's the point that they're making here. Now, from a standpoint, federal law supersedes state law. And if there's any conflict between state law and federal law, state law fails. I mean, we learned that during the marijuana days with California trying to get pot into law. All things being equal, what they're saying is this conflicts. But again, as I pointed out, it's somewhat of a pinprick hit. They may be looking for any leverage or anything within federal guidelines that can go after the various states for things that they put into their very local laws. That's true. But also those states can change those laws to basically evade this, especially if they were able to put that law in the first place. They have the opportunity to potentially put that law. And again, just with a carve out for the explicit things that the federal government comes up with in order to challenge those laws. Now, I guess the catch becomes, how long can you do this before you get to a point where there's nothing else to challenge and those states have basically outlawed abortion? I don't know. I don't hate this. I actually like this. It's like if you're playing chess, you're making where there's time, there's hope. My opponent can screw up. Something can happen to intervene. But if I accept this loss as is, meaning if I accept this situation as a loss, because it's inevitably going to be a loss, then I've lost all chance and capability or potential to do something else. And so, yeah, you try to hold the enemy back at every step of the way. And in this very specific case, now they're basically stuck with pinprick strikes in order to basically try to keep the Republican states at bay for putting this abortion thing into play. But let's just be clear, inevitably, inexorably, they will lose this because, again, those states have already passed their own laws. They're Republican-held states, and unless those states change into something else, those laws are going to stay on the books. We'll see. I don't hate this. This is not me downing it. I do appreciate it. And at the very least, the doctors or whatever would appreciate it if this is sustained in court. But I don't know how long they can do this. I don't know how much they can find into those laws. And all things being equal, like I said, the Republicans basically can change that law. I mean, they're in power in those states. They were able to pass that law in 2020. What stops them from passing another law with a carve out for that explicit thing? Where they say something like, this law in no way conflicts with the Emergency Management Act that the federal government was basically bitching about when they passed their lawsuits. This particular law, if there's a conflict, you deviate to the federal government. They can just put it in the law. Just say, they were bitching about this, so we altered the law to ensure that there's no conflict. Everything else applies. You can do that. You can do that. You can put that in the law if you need to put that in the law. Yeah, Stone Age. Stone Age. I'm going to say like, I'm going to say share, and I'm going to say subscribe. Thanks all.